Person at the Wexford County Jail, please state your name.
Edwin Soderberg.
This is case number 145625FY, the people of the state of Michigan versus Edwin Alfred Soderberg. Sir, you met with somebody from Community Corrections today and you gave them an email address, phone number, and mailing address. Is all of that accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Defender's office today?
Yes, sir.
You've been brought to court on a bench warrant for it alleges that the defendant is in violation of a condition of bond by failing a PBT on December 8th, 2014. You do have the right to have a contested hearing in this matter in which the prosecution would need to prove that to the court, or you have the ability to plead guilty to that violation. Mr. Hartel, how are we proceeding today?
We would ask for a contested hearing, Your Honor.
All right. So we will set this matter for a contested hearing. Well, Mr. Soderberg, since it's been 11 years since you were arraigned on this, I'll just refresh your memory that this is for an operating while intoxicated as a third offender from November 16th of 2014 in the city of Cadillac. That third offender makes that operating while intoxicated a felony, punishable by up to $500 to $5,000 and either 1 to 5 years of incarceration or probation with 30 days to 1 year in jail, and at least 48 hours of that can be conserved consecutively in 60 to 180 days of community service, rehabilitative programs, reimbursements for the cost of governmental expenses, and prosecution. Do you understand? Do you recall those charges?
I do recall those charges.
All right. We will go ahead. So it looks like you had Mr. Harwell in the past, and I believe looks like you retained him. Is that accurate?
Yeah, a long time ago, I remember retaining a lawyer on this, yes.
So you do have the right. So I'm going to go through those rights with you again. You do have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to have be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense.
I understand.
My question to you today is, do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
I would like to have the opportunity to go talk to a few attorneys to see what they have to say, but I may have to, by financial reasons, have to use a court appointed. I'm not really 100% sure where I'm at on that yet.
Well, we can do a couple of things. We cannot appoint one and just rely on you to try to find one, or we can make a request to appoint one, and then you can always let the appointed attorney go if you hire private counsel.
That sounds like what I'd like to do, sir.
You want a court appointed attorney?
Well, for now, so that I can
get sure.
Yeah.
All right. The court will make a referral to the public defender's office for the appointment of an attorney. We'll continue the not guilty plea that was entered in this matter. And since it's been 11 years, we'll reset it for a probable cause conference. Although looking through the file, it looked like there had been an agreement at one point. Procedurally, counsel will address bond. Historically, through this case, it looks like there was an arrest made on November 16th of 2014. He was arraigned on that same day. Bond was set at $15,000 with random drug testing and daily alcohol testing. A pretrial was held on November 25th of 14 and set for a plea and sentence on December 17th. On December 8th, a bond violation was submitted for a PBT of a .067 at 7:45 in the morning. He was told to sit and wait, and he left the building and drove. The bench warrant was issued that same day, and then according to the Register of Actions, on December 11th, a bonding agent had contacted the court that the defendant had been arrested for an OWI in Illinois after
That's
having an
not true.
accident. I'm just going by what the Register of Actions says.
I understand. Yep.
After having an accident, and he had posted bond on that file. Historically, I show that there is an OWI second conviction from '01, and the out-of-state record shows that there was a driving under the influence of alcohol from December 8th of 14, and that a judgment on forfeiture, and I'll be completely honest, I don't know what that means. This is out of Illinois, was issued on March 10th of 17. And then, of course, he's been gone from us for 11 years. The praxis scores him at a risk level 3. Any comments regarding bond, Mr. Hartel?
Yes, Your Honor. I would ask the court to still consider releasing him pending the next hearing. He does have his wife in the courtroom for moral support. I don't doubt she'd pick him up, give him a safe ride home. If the court is concerned for all the reasons that were mentioned, I would ask the court to consider an alternative to the current incarceration, perhaps house arrest with GPS tether. I don't think he has any history of being alleged to have removed any electronic testing devices. That would keep track of where he's at. That way he could only go strictly to work and to court and a few other very specific things community corrections allows. And of course, if the court had any concerns because the original allegations were based on alcohol that require even a daily testing machine if they wanted to, I don't doubt he and his wife would capitulate with that, or his wife would assist him in whatever way she could. I want to phrase that the right way. But I would ask the court to consider literally any remedy other than him remaining lodged pending the next hearing. Thank you.
Ms. Lawrence?
Thank you. Clearly, this defendant is a flight risk. He has been absconding for over a decade from this. And just to remind the court, the lab results on his underlying charge of OWI third came back at a .319, which is frankly so astronomically high. I can't even fathom how the defendant was functioning at that level. And then he ran when he tested positive on a PBT. Given that, I am going to ask for a remand pending a contested hearing as well as daily alcohol testing. Thank you.
I would also like to tell the judge that I'm in the middle of a workman's comp claim where I was actually supposed to go to an MRI this morning. I have a specialist appointment next week, and I have physical therapy 3 times a week at this time. I mean, if you could grant me, like he said, a tether or whatever it takes to make you guys feel safe that I'm not going to go anywhere, I'm 100% okay with that. I have very little money because I'm on workman's comp and it's very, they cut your pay so much. But I need to get a lawyer. Possibly I need to get my foot taken care of. I've been working on this foot for a while. I have a good job at Superior Hardwood, but I can't do the job because of the injury to my foot.
Well, Mr. Soderberg, I'm sorry for that, but the fact is you absconded from this court for 11 years and appears to have been in the area, at least during a portion of that time. You admitted that you remember these charges. I can't, in good conscience, release you. So you will be remanded to the custody of the Wexford County Sheriff's Department until we have the contested hearing. Next, Raymond. Person at the jail, could you please state your name for the record?
Stacy Welch, sir. Can you hear me?
I'm Judge Wiggins in the 84th District Court here in Cadillac. You're here for an arraignment on case number 254568FY, the people of the state of Michigan versus Stacy Edward Welch Jr. Mr. Welch, you met with someone from Community Corrections Office today and gave them some contact information. Was that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, sir.
I have a complaint that alleges that between the dates of October 16th, 2025 and October 22nd, 2025, in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of delivery of methamphetamine. That is a felony punishable by up to 20 years in prison and or a fine of $25,000. In count number 2, and that was for October 16th. In count number 2, is alleged on October 22nd that you did deliver the controlled substance methamphetamine. Again, that is a 20-year felony punishable by up to 20 years in prison and or a fine of $25,000. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I request a court appointed, or is that what it is? I'm
Yes,
sorry
that would
about
be a
that.
court appointed attorney.
Yes, Your Honor. I would like a court appointed honor.
And what is your current source of income?
I work for my dad. We have a tree company. I'm a tree climber, and I also just got my trade in carpenter. But I'm not working for like nobody for the carpenter. I just got it. Like
Okay.
I just got it union to Delta. So
All right. The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that these crimes had occurred, and 2, probable cause that you were the person who committed the offenses. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
yes, sir. So that's within the not today, but the next 21 days, right?
Correct.
Yes, Your Honor. I'm sorry about that.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I've reviewed the praxis. It scores him at a risk level 1. In the defendant's past, I see a juvenile adjudication for unlawful possession of a firearm by a security guard. Any comment regarding bond, Mr. Harrison?
Well, Your Honor, it's a lot of information to take in, especially in a case that carries these charges. I also understand that there was TNT involvement, so it's probably going to be a minute before we have a full and complete police report. But suffice to say, I've got a young man who's gainfully employed. He's not only a high school graduate, he did earn his trade certification in carpentry. He has 4 children, all of whom live at home. He is but 21 years of age, so his children run the gamut 3, 2, 1, and then 5 months. I jokingly refer to that as 3, 2, 1, 0, but that's not strictly accurate either. I know the elephant in the room is the B-Grid delivery and the address in Saginaw, Michigan, but I had a chance to speak with him earlier today and gauge his demeanor a little bit. I can say with a great deal of confidence that releasing him or giving him a reasonable cash bond would not be a mistake here on the part of the court. He's amenable and open to the idea of being on some sort of tether if need be. He does live in Saginaw. He understands that that's a dilemma for the court. There's nothing that prevents him from coming to court. I think there are people who live here locally that have significant higher obstacles in terms of being able to get to court. I don't believe at this point, again, whatever his threat level is to the community is sufficiently allayed by if the court desires some kind of GPS tether or something along those lines. I don't think he's dangerous. He has no past to speak of except for the juvenile charge that I didn't see. Obviously, it didn't come up on iChat. And even that sounds like it was some kind of oddball thing because apparently he was acting as a security guard at the time he incurred that charge. So this is a person with relatively no experience in the criminal justice system with a gainful employment. This behavior seems to be out of his ordinary path because he has no criminal history, even as a juvenile, involving controlled substances or anything like that. I would have the court set. I realize asking for PR is somewhat folly here in light of the Wiggins felony. That having been said, I would ask that the court impose a bond that it would be reasonable for him to be able to post. I can see why the court would want him to have a dog in the fight, and asking him to contribute his hard-earned money would certainly do that. Thank you.
Thank you. Ms. Lawrence?
Thank you. While I understand the defendant's age and lack of criminal history, I think the concerns for public safety seriously outweigh that in this case. Mr. Harrison's right, I do not have a police report, but I do know that the October 16th date, the defendant delivered 57 grams of methamphetamine to Wexford County. And then on the October 22nd date, the defendant delivered for a second time 107 grams of methamphetamine to Wexford County. I think that is extremely concerning to public safety. The fact that the defendant is not from the area, he is from Saginaw, and he is delivering an extreme large amount of drugs to our community. Given that, I am going to ask for a $200,000 cash bond. I would also ask for random drug testing. Thank you.
With T&T, were these controlled purchases?
Yes.
All right, Mr. Welch, as a condition of your bond, I'm going to order the following: that you appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testings. I'm placing you on a GPS tether house arrest with terms set by Community Corrections. I also find that, at least as presented to the court today, the defendant is a threat to the community. He's come allegedly from Saginaw twice within a few days of each other. One day delivering 57 grams of methamphetamine, which by my calculation is about 2 ounces of methamphetamine, and then 107 grams, which is just a little over 3 ounces. So I do find him as a threat to the community as presented today. Bond will be set at $100,000 cash surety with those conditions.
Just for clarity, is that a 10%?
No, that's straight up cash surety. Yep. At least for the time being now, until I know more. Thank you, Jail.